Good morning, everyone. Please be seated. We'd like to welcome, it's a group called Life Class, and for those individuals who are here today to observe Supreme Court, welcome on behalf of the Supreme Court. We're here today for some oral arguments. First is State of Iowa versus Hightower. That case is hereby submitted without oral argument. Excuse me, that was, yes, that's correct. And now we'll begin with the estate of Miller versus Catholic Health Initiatives and others. Are the parties ready? It's my understanding Mr. Appel's going to go first. Is that correct? No? Mr. Ochs? Yes. Okay, well, I was almost there. Gotcha. And you two will be sharing your time, is that correct? Okay, we'll leave that up to you. We don't do the math. We just take the total and you guys do the math, all right? Thank you. You may begin.
Good morning. May it please the court and counsel. I'm Tom Ochs with Rick Stefani. I appear before you on behalf of the defendant physicians, Drs. Nowitz and Carrion. They are emergency physicians who work in the emergency department at the defendant hospital. The gist of the allegation that brings this case into court is that the esophageal intubation of plaintiff's decedent Meredith Miller was negligent because that condition called for a tracheal intubation instead, and the allegation is that that negligence caused her death. 60 days after the defendants filed their answer in the case, plaintiff's counsel served a certificate of merit that was entitled Expert Witness Report and Findings and Opinions. It was signed by Dr. Lynette Mark and was accompanied by Dr. Mark's CV. The certificate was actually in the form of a letter on Johns Hopkins letterhead that was signed by Dr. Mark, but critically, it was not in affidavit form. It was not sworn to under oath. The defendant subsequently moved for summary judgment contending that that certificate did not comply with the requirements of 147.140, and we did so in the form of a motion for summary judgment. The district court held a hearing and then entered a ruling that denied the motion. We were fortunate that the court granted us permission to appeal, and that's what brings us here today.
Ambiguous about the statute's requirement that this certificate be signed under oath?
I believe that there is, and I'm not trying to be flip about it, but the statute itself uses the word affidavit throughout, and if you go and actually count, it says so 5 times. The requirement that the certificate be under oath would be an alternative to an affidavit format. And as I say, in this particular situation, the certificate didn't contain either.
Yeah, but I mean, before you got to the actual hearing, they had fixed that problem. She had signed it under oath, right? So why isn't that substantial compliance?
Because the statute doesn't allow for a second chance, to put it bluntly. That sworn...
Literally doesn't allow for a second chance, but the statute also allows substantial compliance. So you have a signed statement that is on letterhead. I'm sure the doctor meant what she said, and then later she fixes it by getting it under oath before the hearing. Why isn't that at least substantial compliance, even if it's not perfect compliance?
The answer turns on whether you consider the requirement of an oath or affidavit to be part of the essential purpose of the statute. We would argue that it is. There's a reason.
Part of the essential purpose, but is it also is it so essential that it's not good enough if you fix it before the hearing? What if it had been an oversight that was corrected 2 days later? Would that also require dismissal?
The way that I'm reading the precedent, no, that wouldn't be an excuse for missing the 60-day deadline. There isn't a grace period that's built into the statute, and there isn't any kind of good faith exception for failing to follow its requirements.
Plaintiffs get an agreement to extend the 60-day deadline or a court order for good cause allowing an extension?
Your Honor, and as far as I'm aware, it wasn't requested.
The state of Farman, we held that 42 days was not substantial compliance when initially it was just the attorney's signature followed by a sworn expert affidavit. And here we have, over 3 months delay, so more than double the delay that we had in our precedent.
I would agree with that. I would also say that the Farman case stands for the proposition that that certificate being sworn to under oath is an essential purpose. In that case, you had counsel's signature on initial disclosures, and one of the reasons that was held not to be substantial compliance was there was no oath, there was no signature of the expert, and so, yes.
Or what hadn't signed, that's a pretty critical part of that case, but here the doctor did sign, and if she had included, I hereby state under oath, I don't think he'd be making this argument. So my question is, how could you substantially comply with that without exact compliance? Or are you saying that there is no way that you could substantially comply?
Well, the way that I'm reading precedent on the interpretation of the statute, the thing to do if you have a signed statement from the expert that isn't notarized as an affidavit or isn't signed under oath is to request an extension of time before the 60 days expires.
Question from substantial compliance. What does the substantial compliance provision just not apply to the oath?
My answer would be yes. There isn't a way to substantially comply with an express term that requires an affidavit to be submitted. In our situation, the failure of that certificate of merit to be signed under oath or an affidavit form was only one of the two issues that was brought before the district court. The second one had to do with Dr. Mark's qualifications. Under 147-139, it's clear that the two statutes are meant to work together and that the expert under 147-140 has to meet all the qualification requirements of 147-139.
Dr. Marks was eminently qualified to speak to the standard of care on airflow or an obstruction. What was the problem? Where did she fall short?
So, Your Honor, I don't have any qualm with her qualifications per se. But again, looking at the express terms of the statute, the changes that were made in 2017 refer to the licensure of the expert, and it needs to be in the same or substantially similar field. Whether we're talking about airway management or placing an IV, that's the procedure. That's not the field that the doctor practices.
Amendment has legal significance, but what test should we use to determine whether fields are substantially similar?
Fair is to look at the evidence that the parties put before the district court in regard to that issue. This is a case where there wasn't any. The defendants came in, supported their moving papers with the assertion that there wasn't a substantial similarity. that this was a situation where Dr. Mark, as an anesthesiologist, wasn't qualified to give an opinion. And there,
Her CV that showed she's a board-certified anesthesiologist and a lot of expertise in airway management. If it's summary judgment, we review that evidence in the light most favorable to the non-moving party, the plaintiff. Why isn't an anesthesiologist a similar field for airflow issues than the respiratory therapist?
the issue isn't whether the procedure is the same for the two different specialties. The issue is the licensure, and with apologies, I want to give my co-counsel the opportunity to have some time. Thank you.
Well, you can pick up on that, or you can begin on your own.
I think I'll start by saying good morning to everyone. Obviously, I'm Mr. Appel. I represent trauma surgeon Dr. Losh, general surgeons Dr. Perazzi and Dr. Chamberlain, and respiratory therapist Darren Darmaning. I also represent their employer Catholic Health Initiatives. As Mr. Ochs explained today for the appellants, the issue is trying to figure out how the defendants can receive verified information to ensure that the medical malpractice allegations have sufficient credibility to them. This obviously includes the expert qualification issue as well as the affidavit issue. Let's pick up where we left off with the field issue. As I just explained, we just went through all the fields, and this was agreed upon by plaintiff's counsel at the hearing, that the fields we are comparing are anesthesiology to trauma surgery, or the equivalent of emergency medicine, general surgery, and respiratory therapy. Now, the plaintiff also conceded down below that these aren't the same fields. So what's left for this court to determine is whether they are substantially similar. Now, there isn't a great test for substantially similar, and the legislature didn't exactly give us one. But what we do know from our statutory interpretation is that they required the fields to be substantially similar. Substantially is an intrinsic modifier that is used on the word similar. It requires some material similarity or some essential likeness to those two fields.
To Justice Waterman's question, isn't this an expert in airway management, and isn't that substantially what we're dealing with?
With is the differences between those two fields. It's not the field of what the negligent act was committed in. In this case, it would be airway management. We're trying to compare the fields of emergency medicine on its own, general surgery on its own, and respiratory therapy on its own. Now, I think the fact that a procedure can cross over between fields, that might be some relevance, but it's not the determinative factor, especially considering when the legislature decided that they wanted to move away from focusing on the act at issue or the procedure at issue. Certainly.
Language is the person is licensed to practice in the same or a substantially similar field as the defendant. You know more about this than me. What, is he licensed to, are your clients, male and female, sorry, are they licensed to practice in a substantially similar field to the expert at issue here?
To practice in the same field. And that's what this subsection 1 is really getting at, that you have the ability to work in a certain field. The second subsection, which is what our defendants, the CHI defendants, are really focusing on, is whether they actively practice in that same or substantially similar field.
I mean, don't we kind of interpret those in tandem? So if they are licensed and the license is a fairly broad category, then and the field, the term field gets a broad interpretation there. Why doesn't it get a broad interpretation in the next paragraph?
Read this paragraph with subsection 3, which is the specialty provision. From what I understand of the medical literature, a specialty and a field are more or less synonymous. When you take a look at the ABMS, for example, or the American Osteopathic Association, they routinely refer to a specialty and a field as interchangeable. That also includes our case law on the issue, such as Shover, Carolyn, and Hutchinson from our previous cases interpreting the old expert qualification statute. So I don't think the term field is as broad as what the court or what you're asking, Justice Mansfield, excuse me. But it has to be a little bit more narrower and not just focused on.
Agree, normally when we have we've said this before in opinions, that when you have a statute that uses a term like field in this case, that normally we interpret that field the same way in each of its uses within that statute, right?
Just say that you'd probably interpret that this court should interpret it similarly as what it's going to interpret a specialty as, considering the medical literature out there, considering how this court has used the term specialty and field interchangeably in its own case law that the legislature recognizes.
The approach of the Virginia and Maryland courts where to interpret a related field under the Virginia statute, they looked at the treatment at issue, and if there was overlap between the plaintiff's expert and the defendant, and the overlap included that, that particular treatment form. So here we've got airway management, we've got an anesthesiologist who deals with that. I think normally they're the ones doing the intubating. So would that make sense?
I see my time has expired. Can I answer Justice Waterman's question? No, Your Honor. I mean, thinking back into the old statute, the legislature clearly designed a new statute that doesn't focus, or at least doesn't put a heavy focus on the procedure at issue or the treatment. The legislature could have modified the word field to include the specific act at issue. It clearly understood it based on the legislative history where the legislature had the idea to have the expert be qualified in a similar procedure, but got rid of it, which this court has typically looked to as a whole. With those, I'd leave it for plaintiff's counsel. Thank you.
Thank you, Your Honor. May it please the court.
Just a little bit closer to you. Thank you.
May it please the court. Counsel. So as we sit here today, I'm not entirely sure what the appellant's position is as it relates to this statute. Are they saying that the expert needs to be in the exact same field as the defendant in the case, or are they saying that there is a definition of substantially similar? Because, again, as we sit here today, I don't know what that definition is or what it means. Our expert, Dr. Lynette Mark, is very qualified in airway management, and that is the procedure that was performed here. This is an issue of first impression for this court. I'd like to jump straight to some persuasive authorities here that was already brought up and mentioned, because I think it's really important that, given that the Iowa Supreme Court has not decided these, that we look at these specific cases for some guidance on how to interpret our statutory language. So the first one is Sammy v. Barn. It was decided in 2000 by the Virginia Supreme Court. Plaintiff Sammy filed claims against emergency room physicians in an OBGYN. The allegations were that these emergency room physicians in an OBGYN failed to identify a second uterus containing a deceased fetus when the plaintiff presented to the emergency room with abdominal pain. The plaintiff sought to use an OBGYN at trial. The trial court found that the plaintiff could use the OBGYN to testify as to the standard of care against the other OBGYN, but could not testify as to the emergency room physician. Again, somewhat similar to what we're dealing with here, because we have an emergency room physician and we have someone in a different field, and I'll get to that in a second, which is anesthesiology, testifying as to the standard of care. The Virginia Supreme Court reversed, finding that the related field language in their statute, so again, same language here, it's related, substantially similar field, that incorporated the procedure in which they were performing.
That statute does talk about field, but it also has a separate part that talks specifically about knowledge of the standards of the defendant's specialty and of what conduct conforms or fails to conform, and that part is very different from our statute. And actually, it used to be part of our statute or something similar, and the legislature removed that. So can you speak to those differences?
I think that's incorporated in the statute that we have because it requires the expert to specifically testify or say that they're familiar with the standard of care. So they're talking specifically to this practice and the procedure that's being performed. They have to testify or they have to state that they know what that standard of care is. So I think what you'll find is that all of the language, sorry.
Clarify, that's coming from 147, 140, not the qualifications themselves. The qualifications themselves don't, I mean, that's before we even get to them being able to give their opinion. But with respect to 147, 139, our legislature removed any reference to the actual conduct at issue. Is that correct? And what do we do with that change?
Your Honor, but essentially what they've done here is just made it simpler. They've paraphrased the language, and if you look at the legislative history here, one of the important pieces to consider is that the first draft of this bill, there's 4 drafts. The first one actually has that the expert must be licensed in the same field. There's no language that substantially similar is there. So if we read this the way that the defendants are proposing, that makes substantially similar completely irrelevant and meaningless.
That would have prohibited you from having the expert that you think is the best expert and then somebody who's actually licensed in emergency medicine. Couldn't you do 2?
Correct, Your Honor. We could have done 2.
Anesthesiologist in virtually probably every procedure out there that's either emergent or scheduled surgery as well?
To a certain extent, Your Honor. I think that there are some things that they couldn't speak to if it was trauma surgery and the way the surgery was performed. Then I don't believe an anesthesiologist would be qualified to testify, which of course, certainly that would be up to the court to decide. But that's not someone that I would select for that type of a procedure. So in this case, we have Dr. Lynette Mark, who is extremely qualified, not only in anesthesiology, but in critical care medicine.
I see a practical question about the statute. So I'm reading this license to practice in the same field. And unless I'm wrong, and please tell me if I am, they all hold medical licenses, correct? And if you read 136A, it applies to a whole bunch of people other than doctors. So it says pharmacists, podiatrists, dentists, nurses, physicians, DOs. We can deal with the issue of specialty later, but they're all licensed in the same field. They're licensed doctors, correct? Yeah. So why doesn't that resolve the issue? And then we can just move on to the specialty provisions in subsection 3, which is very different. But am I missing something on this licensure issue?
Your Honor, that's something that we believe as well, that if you're talking about a physician, how do you define field? It's not defined within the statute. So Merriam-Webster, which is cited by both the appellant and the appellee in their brief, specifically states that field is an activity, subject, or profession. So how you define that, I think it's broad. You have to look at each case as it comes through on a fact basis and say, what do we have here? What's the defendant's licensure in? What do they do? What's their field? Also, what is the activity being formed? You can't look at this in a vacuum and give it such a strict reading as the appellants are proposing here. That makes most of the language that's in it completely irrelevant.
Specialty part of the statute, and we have surgeons here. What's a substantially similar specialty to a surgeon?
I had a definition of that in the code. That would make things a lot easier here. I think in each case, the plaintiff and the defendant are going to have to introduce evidence to determine. It's like qualifying any expert that we have right now. When we're looking at whether or not it's a same or substantially similar specialty, does it satisfy the first provision by just both being physicians? And if that's the case, then we get to this next provision, and they have to be in a same or substantially similar specialty. And that's not the issue on appeal here today, but what I would say is that again is a fact question that we would need to look at in each case to determine whether or not it's a substantially similar field.
To the oath question. Read that letter. There's nothing in it that says, I swear, I affirm, under penalty of perjury. What is it that would substantially comply with 140?
Your Honor, there's actually another case that I was hoping to get to at some point, so you brought me there. That case is another persuasive case because this is, again, a first impression for the court. But that is Reed versus St. Barnabas Hospital. Another one that's a New Jersey Appellate Division, Superior Court of New Jersey Appellate Division case. The trial court in that case granted the motion to dismiss because the report of plaintiff's general internist was missing an oath. Again, very similar, I mean, almost identical to what we're dealing with here. They produced a letter in that case that was signed by the expert on letterhead. And what the appellate court did is they reversed, finding substantial compliance. And that's what's written specifically into the statute is substantial compliance.
Let me push back just a little on this. I think that your opponents pointed out, the legislature's gone out of its way to make sure that this is not just a letter, it's an affidavit. It says it 5 times. And if, our code contains a definition for affidavit, 62285, must be a written declaration made under oath. I don't see any wiggle room on that, and I don't know how you can get past that.
Your Honor, how I would respond to that, I mean, if I could go back and this could be an affidavit form, would we do that? Yes, under oath. That's why we went ahead and corrected it. But if the language says substantial compliance and we read strict compliance into this, I think we've definitely transitioned from what even the court said we're supposed to do here. The court decided struck recently, and in struck it says that we're supposed to read 668.11 in tandem with these new statutes. And when you look at that, 668.11 didn't even have substantial compliance the language built into it.
Justice McDermott was talking about under oath, I swear, under penalty of perjury. So you didn't have the notary signature, you didn't have the magic language. It's just on a letter. So then let me see how far you'd take this. How about if they just texted that same stuff and you submitted a photocopy of the text? What makes the other version more substantial?
In this case, I think specifically because it's on Johns Hopkins letterhead.
Can be part of your signature line on a phone, sent by my email or sent by my letterhead on the bottom?
Yes, Your Honor. And certainly that's a risk that comes into play. I know we were talking earlier about another case, I believe it was Farnham, but if the only thing missing is the oath, then that's where we believe that substantial compliance comes in.
Thing, oath? I mean, isn't that probably the biggest part of that requirement is swearing that it's true? And you can be held to penalty of perjury. That's not, if that's the only thing, isn't that a big thing?
I think it's a big part of the statute. I don't think it's the most important. It doesn't go to the objective of the statute.
Your substantial compliance argument have to involve sort of a combination of the things. A, that the original thing was signed, and B, that it was corrected. I mean, if you had it signed but never corrected it, then it seemed to me that would be a tough case for substantial compliance.
A big part of that is we worked with the doctor to get that updated upon those.
In Farman, there it's just something that the lawyer put together. So then if the expert's on the stand, it's kind of hard to cross-examine the expert with something that the lawyer wrote and that the expert didn't sign or specifically adopt. Whereas the difference between something that somebody signed and when they're on the stand being cross-examined and something that's signed under oath is less of a difference, it strikes me.
I think the doctor, as soon as they sign that in their name, they're putting their reputation on the line.
Would you agree with me, though, that signing that letter would not open that doctor up to perjury, unlike an oath.
The existing Iowa case law, yes, that's correct. State v. Carter specifically deals with that, and they did hold that a signature on an application simply certifying the correctness of the information given was not enough to open them up to a perjury charge. But that's also different than what we're dealing with here.
Isn't that the point of an affidavit? If there's any measure of what an affidavit would be, it would have to be that it would subject the signer to perjury. I think we've got some old case law that says so, right?
And certainly, that's an important piece of it. But again, if we read this solely to say that you absolutely have to have every piece of this statute, where does substantial compliance come in?
The expert would never have to sign it under oath? I mean,
Ideally, the expert would sign it under oath.
if you say a letter on Johns Hopkins letterhead is substantial compliance with an affidavit, then why does the expert ever need to sign an affidavit?
Well, I suppose if that's the only thing missing, then that would be our argument, is that it is substantial compliance.
In this case, for everything out there that requires, such as petition for dissolution of marriage, a financial affidavit, can they start citing this case and saying that doesn't mean it? They don't mean it. It's interpreted substantial compliance. They signed it. That's good enough.
I certainly think they're different contexts. So I think in this situation, you have a statute that also has, you're reading our liberal rule on experts into this as well.
The substantial compliance as it applies to the affidavit. Let's assume the affidavit itself was defective, but there was an attempt to have it signed under oath, or maybe the declaration of signing it under penalty of perjury was defective and not exact. That seems to me to be more of a substantial compliance argument rather than what you're saying here, which is if she never signs an affidavit and she never declares it under penalty of perjury, but it's on letterhead, then that's sufficient. I mean, those seem very different to me.
I mean, essentially what we'd be saying here is that, we believe that the doctor's lying after she puts her name on this on an expert letterhead. It's her reputation, it's her license at stake. I think each case is going to be a little bit different. If someone just...
Sanction.
And
Which is what the statute requires, that she subject herself to penalty of perjury by signing something under oath. And if she puts it on her letterhead, that doesn't happen.
You're right, Your Honor. I mean, she's not subject to that. Again, we're still arguing that it's substantial compliance with that statute, and we did cure it by subsequently providing. I think that the court has also added in, I see that I've gone over my time. Do you mind?
Not.
One of the things that we've built in as Iowa courts into substantial compliance is prejudice. And what the district court noted is that the defendants have not shown any prejudice by the appellees failing to produce it under oath, especially given that it was subsequently cured and that the affidavit was then provided under oath.
Prejudice look like? I mean, as a practical matter.
I think that's tough to answer, Your Honor, but I'll do my best. The prejudice, I think, would look, maybe you have a doctor who is known to have a history of writing reports and perhaps not being as consistent, or they don't have a chance to take their deposition because the expert suddenly passes away afterwards. Then I think suddenly you've got a problem, because you don't have someone testifying under oath. But in this case, they can certainly take the expert's deposition, which would be under oath. Thank you.
One of you is back to bat. Mr. Oak, okay.
This is going to be a little bit scattershot because I want to address a number of different issues, but I want to be...
Prejudice?
Putting the microphone a little bit closer. I got a message that they're having a hard time hearing you. We want to hear you.
Starting with the prejudice, the statute doesn't permit for consideration by the district court of whether the failure to comply caused prejudice. It's just not there.
In the state of Farnham, right? Okay.
Not for the first time, but you're a step ahead of me. With respect to the affidavit, I've said earlier that the question on substantial compliance is whether the effort to comply met all of the essential purposes of the statute. And our contention is that having verified information is an essential purpose in this particular case.
But you got it a little bit late, and you got on time something that a very distinguished physician from one of the leading medical schools in the country had signed personally, which probably showed that it wasn't a lawyer's answer like in Farman. So why isn't that enough? Why isn't that a compliance with the essential objectives to get a signed letter followed up by confirmation before the hearing that it was under oath?
Because the timing requirement of 147, 140 is also an essential purpose. The 60 days means 60 days. The court has so interpreted it, and there isn't an opportunity to come back 3 months later.
I mean, if you're just saying follow Farman, okay, I agree under the Farman circumstances where it's a lawyer's answer. But why doesn't, just tell me in straight English, not talk about cases, why isn't that substantial compliance? Why doesn't that get you essentially what you need?
But that's a decision for the legislature to make. They didn't refer in the statute to the idea that you could correct what you submitted within the 60-day time frame. In this situation, it was 90 days that went by, and it was after the content and the compliance issue was raised by a motion to dismiss from our co-defendants and motion for summary judgment by ours. I also want to point out that if you look at the district court filings the plaintiff made, there's reference in there to the fact that they made every effort they could to find an emergency doctor to provide verified information, and they couldn't do it because he wouldn't respond to their question. That's an acknowledgement on the plaintiff's part of what the statute really required, not Dr. Mark coming back and vouching that something that was already submitted was genuine. I think in this situation, it's also necessary to spend just a couple of minutes distinguishing those new authorities that were cited. And if you'll indulge me, I'm going to read to you from the Sammy versus Varn case from Virginia. Quote, "In this case, Dr. Roberts testified that he was familiar with the standards of care applicable to pelvic examinations and, excuse me, that those standards were the same for an emergency room physician and an obstetrician gynecologist. Dr. Dill, a defense witness, testified that she knew of no variation among the medical profession." What's important there is that that case is a decision that came after a trial where the experts were able to provide live testimony that went to the question of whether the two fields were substantially related, that went to the question of the overlap.
Record that they have a different standard of care for intubation?
There is indication in this record that the practice of emergency medicine is not the same as anesthesiology. And again, we're not focusing on the procedure that was at issue. This isn't the problem that was at issue, it's the qualifications. I see my time has expired. Thank you.
Miller versus Catholic Health Initiatives and others is hereby submitted. And we'll have a brief pause here while the next attorneys get ready for their case.